make sure you stay to the end to win this or this for free. Check it out. I don't know if we all gonna agree when we get to the very end of this clip because, man, the judge might have messed up on this one. Or maybe she didn't. Let's get to it.
For hearing on the defendant's motion for new trial that was filed on August 11 of 2025. So are both sides ready to proceed?
Yes, Judge.
Yes, Your Honor.
Okay, thank you, and good afternoon, Mr. DeCoste.
Good afternoon.
All right, it is the defense motion, so I'll go ahead and hear your argument. Who's going to make the argument?
Your Honor, I'm going to make the argument. It's brief.
Okay.
Our argument relies heavily on what was written before Your Honor. The thing to add to that is the way that the demonstratives played out. Ms. Quas may have to jump in here and add it for me, just if I forget something, but I know Your Honor only wants one attorney. So just as a reminder and for the record that we specifically requested copies of all demonstratives at the hearing on the motions in limine, which was granted. The state said there were no demonstratives, and the demonstrative with the notes, which is, I would say, core to our motion for a new trial, the demonstrative that contained those notes was provided to us the morning of the day that it was introduced. Other than that, Your Honor, we rely on the motion that's been filed with the court.
Okay, thank you, and I'll hear from the state.
So, in a court of law, a demonstrative refers to the use of physical or visual aids or even an in-person experiment or reenactment by a witness or attorney to help explain or prove a fact in dispute. These demonstratives are often called demonstrative evidence or illustrative aids, can take the forms of maps, models, charts, diagrams, photographs, videos, or a witness physically showing how an event occurred, all with the purpose of clarifying testimony and assisting the judge or jury in understanding the evidence. So now that y'all understand that part, let's continue on.
Judge, with regard to what defense counsel is claiming is a demonstrative, I believe he's referring to the notes that were admitted as evidence that came from the iCloud account. There was one demonstrative that was used by the state. That was the PowerPoint that depicted the faces and names and nicknames of the individuals.
That you used in opening?
That I used in opening. That was not put into evidence. That was the only demonstrative that the state used. The notes were put into evidence, and that was not provided to counsel the morning of trial. That piece of evidence, all of the state's evidence, had been made available to the defense. I had asked them to let me know when a good time was. I would walk them through my case and all of the evidence I intended to introduce. They declined to participate in that. They declined to do that. I left all of the evidence from the state in the courtroom, from jury selection on through the end of the trial. They could look at it at any time they wanted to. It was available, present, and they had possession of it. So that was not something that was turned over to them the day of that particular testimony and they were caught off guard by it. That was something that was available and made known to them for years.
I recall our conversations about that. I can't recall what date. I'd have to look at my notes, but I do have recollection that I inquired about when the exhibits were introduced, when the defense reviewed them, or the fact that they consciously did not view them, if I recall correctly, to prevent the state from saying they reviewed them, something like that.
Right, the defense mentioned...
But let me be sure what we're talking about is the same thing, apples to apples, because you're talking about demonstrative aids. Other than that PowerPoint video of the faces and names that the state used in opening, what other demonstrative aids did the state introduce, or not introduce, that did the state use in trial that you had not seen prior to trial?
Okay, so Your Honor, and I will break that up. Of course, there are the iCloud notes. That is a separate argument, and that is something that is purely prejudicial. So setting that aside and just focusing right now on demonstratives.
Right, because those were actually introduced as evidence, so that's not a demonstrative aid, the notes.
Correct.
Correct, okay, so go ahead.
Correct, Your Honor. So to break it up so there won't be any confusion in between demonstratives and notes. As for the demonstratives, we brought it up pre-trial and asked, and the government said we have no demonstratives. It's in the record. Every single demonstrative that they then brought into evidence was something that was thrown on us during trial. That included the stuff from the cell phone experts. So the government saying that this stuff was available to us, for years, That's separate. That's a separate argument than what we're talking about on the demonstratives. Ostertag's demonstrative was, and again, I apologize if I confuse it. I know that the cell phone experts, both the federal witness and also Ostertag, who's with JSO, that they both had demonstratives. One of them may have been entered in as an exhibit, but I know that one of them had a demonstrative. So Ms. Kwasa is shaking her head, so I believe that that's right. So the government saying pre-trial, we don't have any demonstratives, then rolling into trial and handing us stuff that were demonstratives that was not given to us in discovery, that was not given to us as evidence, that was given to us as a demonstrative literally when they're being admitted. As for the notes, which is a separate thing and a separate argument, which is within the motion before Your Honor, those notes have no relevance. Those notes predated everything the government was bringing up in the case. The government was allowed to introduce it in. It talks about specific acts of violence identical to this case, and there is no way that the jury removed that from their mind when they were making a determination of guilt in this case. There's no way that that should have gone before the jury, and I don't think that the government can articulate how a note that was authored, and we know when notes are authored, even if they're edited, that it changes within Apple iCloud, and the date that's on it predates the death of Willie Addison, which was believed to be the reason why Charles McCormick wrote the song and the reason why there would have been motive to commit the murder here. I don't think the government can articulate how that note was at all relevant to this case and how a jury would be able to disregard that note. And again, it's all contained within my motion.
Yeah, and I understand the argument about the note. That was an exhibit in evidence, not a demonstrative. I understand you believe it should not have been admitted, and certainly the appellate court can tell me if I have made an error in that regard.
So basically, so far they saying, bruh, they introduced evidence, even though he slick said in the beginning, well, we didn't admit it in the evidence, but we used it in our opening statement. Bro, what? That's still, you know what they say when they say, you know, bell that's been rang can't be unrung. Meaning once you hear the sound, you can't unhear it. Once you see it, you can't unsee it. So it's not like this freaking case lasted for weeks. That ain't what happened. So right there to me, I'm not a lawyer, but you know, I play a damn good one on YouTube. That seems like that's enough. But the judge, she basically like, the appeal court is going to be the one to do it. So let's continue on.
Trying to go back and recall and review in my notes and otherwise are what you're describing as demonstratives by Agent Corley of the Federal Bureau of Investigation and the cell phone forensic examiner, Mr. Ostertag of the Jacksonville Sheriff's Office. And I'm just trying to go back to my exhibit list and my notes to recall whether those, I believe FBI agents were moved into evidence.
That is correct. There was a PowerPoint presentation that contained slides that the agent had created that depicted the cell phone tower locations as well as the location for the phones based on incoming, outgoing calls and data files, and that was moved into evidence. With regard to
Your Honor, I apologize for stepping in, but just in order to assist the court, just so that it's clear, is I know the state is saying those were moved into evidence. We were always, and I think we objected that all of those things qualified as demonstrative aids and should not have been admitted. So when we say demonstrative aids, in our eyes, those were demonstrative aids and admitted over objection. So, for example, when I think I was the one that made the request at motion to eliminate that any demonstrative aid or anything of that sort be provided to us ahead of time so that we can scour through it to see if there was anything that was going to be objectionable within it. The thing in particular was the Ostertag, what I would classify as a demonstrative, but was admitted into evidence over our objection. That was provided to us the morning of. Was never provided to us before. We had a brief moment to try to scour through it before the court inquired if there was any objection. I believe we laid our objection that it shouldn't be admitted at all, as it is merely a demonstrative aid. And that, I believe, was also the piece of evidence, the compilation that contained the notes. We then discovered, we were only able to discover the date timestamp of the note after the court had admitted it into evidence when we asked the state to provide us with Mr. Robinson's physical phone, which we never had access to before. But we then looked into it and was able to determine the date and time. That was brought to the attention.
And if y'all remember in the past, before the Hernandez-Govan case, we used to actually believe, man, a cell phone tower can ping this and ping that and all this stuff and whatever because your phone automatically hit this. it turns out that those cell phone towers can get full and your opinion is something else. So it's not as though the cell phone tower stuff is an exact science. So, bruh, I'm listening to this crap and I'm like, man, come on, man. Like, first off, you said you didn't use it, then you came back and said, actually, yeah, it was admitted in the evidence. And now it's a whole different story, bro. New ball game, new rules, different scores. That's what it sounds like, bro. I don't know. Maybe I'm tripping. Y'all let me know right now. Hit that like button, too. Let's get out of here with what just happened, bro. Roll it.
On your motion.
No, Judge, I think everything else we're relying on all of the argument on, as Mr. DeCoste wants to jump in, everything that he had put in the written motion.
Okay, anything else from the state?
Judge, just regard to the last part, again, regardless of what we're calling it, these pieces of evidence that I offered at that hearing to show them every single thing that I had and intended to introduce that would go before the jury. They deliberately decided not to look at that, and I believe during trial articulated to the court that that is their common practice because they don't like to look at something and say that they have reviewed it, and then later something that maybe they did not see was introduced. And that's their practice, and that's fine. But I've listed everything in discovery, I've did an exhibit list that outlined everything, I left it in the courtroom, and I offered weeks before this to walk them through every single piece of evidence that I intended to introduce. They had copies of it, they were aware of it. I don't know what else I could have done.
Okay.
Your Honor, I can reply to that, please.
Okay. Last thing, because we've gone back and forth, which is
Well, it's our
what
motion
we
that-
normally do, but go ahead.
Just for the record, it's our motion. We made the initial argument. They responded. I would want to reply, if the court will allow.
Well, I was allowing him to respond to the ora tennis addendum, which was not included in the motion. So if you want to reply to that only, then you may. I think I've heard enough already about the other issues.
Understood, Your Honor. The standard practice that I explained on the record is this, that the government under 3.220 has an obligation to list and provide all items of discovery. As a matter of practice, when a prosecutor says, hey, come and take a look at our file, I decline to do that because it opens up an opportunity for a prosecutor to say, well, it was in my file. You would have seen it, but you didn't look at it. So this was not a situation of us being dilatory or us trying to be willfully ignorant. We said, anything that you have, provide it to us so that there is a receipt, so that there's a record that we know that we have it. As for these demonstrative evidence, it would have been as easy as Mr. Cooper loading it into an email and sending it to us. The government chose to wait for these, what were initially introduced as demonstrative exhibits, to wait to provide those to us. That is not the right way to do it, and it's not right to say that somehow we didn't because we chose to not physically go to their office and look through their file for the reasons that I had explained. As for the notes, I still don't think the government has articulated how a note from 18 months prior, when they moved to introduce it to the court without telling the court that the note was so old. Remember, they had the phone, so if we're talking about looking at evidence, they could have looked at their own evidence, the phone that was in their possession, and said, hey, we're trying to move into evidence a note that is years before any of this incident, but they didn't look at that. It was only because we shared that with the court. I think for that reason alone, that it would mandate a new trial. As for the demonstratives, I've made my argument. Thank you for allowing me to reply.
All right, thank you so much. All right, well, of course, the 4 issues raised in the motion were all addressed during the course of the trial. Objections were raised by counsel. The court heard the argument from the parties and ruled on them. So that none of this is new that I hadn't heard before. But having considered the motion in its totality, and of course, having sat through the trial, at this time, I'm going to deny the motion for new trial.
And that's crap. That's flat out crap, bro. That's something that you can't, you're not supposed to be able to do. Basically what they're saying is they had a bunch of stuff and they wanted us to come see it. Instead of these cats essentially saying, hey, we're going to submit all this via e-file so that it's all documented. And they decided not to. They decided, meaning the state decided to say, no, here's our files, come over here, come look at it and all this crap. And they're saying, no, why don't you submit it so that we have a receipt so that it's here? Because technicalities exist. Because I can guarantee you, If this been the freaking defense, man, that judge would have said hell no. So based on that, bro, I'm going to say that the judge is 100% wrong. It just is. You can't sit up here and say, oh, I got all this evidence, and I say, hey, I need you to e-file it so that we all have it, and then you say no. We're not in the freaking 1980s, 1970s. So, bruh, I think the judge 100% got this one wrong. Do I believe Ksoo is basically guilty? Hell yeah. And she basically further goes on to say, essentially acting like none of this stuff basically hurt the case, is how her blasé attitude was. So, but as far as this case go, man, I think he deserves a new retrial. And on the appeals, I think that's what's going to end up happening. I could be wrong, but I did pull it up. Let me see. It is doggone FRE 401 and FRE 107. So we'll see if they follow the freaking rules to the T. If they didn't, then we'll get a new retrial and all of this stuff and everything. And they'll get to, I don't want to say destroy the cell phone tower evidence, but it would behoove them not to go ahead and hit up Manny Aurora from the Hernandez-Govan trial and look at his people and use them, because I think they can get a lot of this stuff thrown out personally. But once again, I believe he 100% did it. But we can't have the good team and the bad team, and then the good team is basically doing stuff that the bad team does to win, because they're no longer good. It just is what it is, man. But hey, you stayed this long, click, you want this or this, just be a subscriber, like every video, comment on every video, and you're automatically entered to win. You had to do it every single time. Don't take a day off. Don't take 2 days off. Do your part, so that way, bruh, we're going to climb up. The more comments, the more likes, the more YouTube pushes this to the algorithm. And you know, people like what we spilling up over here. But click right here and see how the internet just lied on YNW Borland and said he's going to tell. Actually, factually, false. And we show the proof. Even the lawyer had to come out and say something. But click right there, and I'll catch you on the next one.